Joining us to discuss today's judgment is Sinawo Makangela, legal practitioner and director at Makangela Incorporated. Good evening, Sinawo. Thank you very much for joining us on the late edition. Firstly, your reaction to that judgment dismissing Nandipha's bid to have her deportation declared unlawful.
Thank you, Bundo. Thank you to the viewers as well. Yes, I read through the judgment. It's a very interesting one, of course. A lengthy judgment that one is going through even now. You can't just read it once and come to a clear conclusion. As you heard, even the legal team for Nandipha is saying they want to study it as well. But it's a very interesting one.
But now, many have argued that even if the matter were perhaps to reach the Constitutional Court, because some believe she'll probably exercise that right, they say that, if anything, this matter is now academic at best, so it would merely develop the law. So most of you legal practitioners are looking for that. Because Nandipha's legal team had maintained that what happened in Tanzania was in fact an extradition disguised as a deportation, purely because an extradition would have taken far too long. What has been your long-held view on just that position alone?
Well, I don't think it's academic. She's in jail. She's incarcerated as a result of that arrest that was effected, as she alleges, that was effected in Tanzania. So it cannot be academic when she's behind the bars. And well, that's what she's arguing, actually. In fact, if you look at the minority judgment, it turns on that very point, that because the approach in this matter is what is called the motion proceedings. So in the motion proceedings, you only have three sets of papers. It's the founding affidavit by Nandipha and the answering affidavit by the states, that is the ministers, as well as the replying affidavit. So the case is only made in the founding affidavit. So the SCA says Nandipha tried to make her case in the replying affidavit, of which that is not allowed in our law. So it is turning on that very point that it only came at a later stage that it was an extradition, sorry, it was a deportation disguised as an extradition, what she was subjected to. But the SCA, Judge Zonde, writing for the majority, says, well, all what Nandipha is saying, all that came at a very later stage. Actually, it came as well in the heads of arguments where she started to make her own case. But that's different from what the minority judgment is saying. Judge Makangela says that is not the case. That is not true, you know. But that is not the only issue. The second aspect, which I think is very important, because the SCA ventured into a space or dealt with the issues that did not serve before it. That was not the ground of appeal, because if that was an issue where the ministers said Nandipha made her case in the replying affidavit, that issue was determined by the High Court judge. But the state did not file what is called a cross appeal at the SCA, but the SCA found itself determining an issue that was not appealed against. So that's exactly what Judge Makangela is saying in his minority judgment.
And then for those in your fraternity that still hold the view that it's academic, it seems that they're saying that even if this matter got to the Concourt, and perhaps the Concourt would have ruled in Nandipha's favor, that what would still remain are the charges against her. That fine, it would be indicated that the Bloemfontein High Court has no jurisdiction because, in fact, she would have been somebody who was taken illegally, from Tanzania. That what would then happen is that they would essentially effect an arrest on any good day, and then the process would begin yet again. Where do you stand on just that, for those who maintain that it would really just lead to the same outcome nevertheless, even if they found in her favor? It's not that she would be taken back to Tanzania and then again the process is started.
But it knows. It happens all the time. Somebody gets to be arrested unlawfully. What becomes the position? Because the court does not exonerate someone from committing an offense. But in the process of bringing that person before our courts, it's what is wrong. So the law enforcement agencies will have to follow the law if they so believe that they've got a strong case against her. Because the issue here, if you could see, if the majority judgment, they even say she does not attack the arrest at Lanseria Airport. She's only dealing with the arrest from Tanzania to South Africa, because she says she was arrested there, she was blindfolded there, meaning whatever happened in South Africa is not an issue because the whole process started in Tanzania. It was the continuation, according to her version, or the conclusion that I make is that It was the continuation, anything that happened in Lanseria. But you can't say it's academic. Remember, the person is in jail as a result of that arrest. What followed the arrest was her detention. So if that arrest is declared unlawful, that declaration does not mean she cannot be arraigned for any criminal offense that she would be a suspect of. But for that process, it would take her out of jail. Well, whether she comes to court tomorrow, perhaps she will be coming from her own house to attend her cases.
But there would never be a scenario where they have to return her to where they actually apprehended her, which would be another country in this respect.
In respect of that very issue, because the court would have pronounced, otherwise it would be tantamount to some kind of being contemptuous in their conduct. Other papers would have to be processed, and then they know which route to take if they want to bring her before courts.
All right. Sinawo, thank you very much for your insights this evening. That's Sinawo Makangela. He's a legal practitioner and director at Makangela Mtungani Incorporated, speaking to us there.